Hey guys, what's going on? It's attorney Edward Littlejohn here to go over the real estate and probate question of the week. Today's question comes from Marcus. Marcus wants to know, is a land installment contract required to be recorded under Ohio law? Well, this is a great question. So when it comes to land installment contracts, the law requires that they get recorded to be effective amongst the parties. Okay. Essentially, a land installment contract is a kind of like a rent-to-own scenario. And so what you commonly see are situations where the vendee, also known as the buyer, has the contract recorded, and then they take that recorded contract to their bank, and then they're able to get a loan to pay off the seller or vendor. So it's recommended that they be recorded to protect your rights. However, what we see a lot is where a seller may have a mortgage on a piece of property, and if they record the land installment contract, it'll trigger an acceleration clause under that mortgage. And so as a result of that, the land installment contract does not get recorded to protect and preserve the seller's rights. In those instances, if there's any wrongdoing or bad faith that's occurred between the parties, then the buyer or the seller could sue for breach. Not recording the land installment contract is more beneficial for the seller than it is for the buyer. If you're a buyer, then you're going to want to have that land installment contract recorded so that the property can't be sold without your permission, it can't be transferred, and that the world is put on notice that you have a right to this property. However, if you're a seller, you may not want to record a land installment contract because it'll show a lien or encumbrance on your property should you desire to sell the property. In any event, if you guys have any questions on real estate or probate matters, give us a call, 740-346-2899. Our team is here to help.